hereby issued staying the furtherance or implementation of the resolution of the Senate, Your Lordship. The Senate is not a party to these proceedings, Your Lordship. How can it be that parties benefit or seek to benefit from conservatory orders wherein those parties have not been sued, Your Lordship? I submit that cannot be the case, Your Lordship.
Yes.
In any event, Your Lordship, as submitted in paragraph 54, order number 3, which was granted, restraining the Speaker from publishing or causing to be published in the Gazette notice, was overtaken by events, Your Lordship. They say that the Gazette notice was predetermined, Your Lordship. We have at length given explanations and reasons as to why that is not the position, Your Lordship.
In brief, why isn't that the position?
Your Lordship, when the Senate undertakes its business in accordance with the order paper, there is the order for the day, Your Lordship. The order for the day was the impeachment, Your Lordship.
Yes.
And Your Lordship will notice at paragraph 46 of our replying affidavit, we have at length explained what happens when there is a division, Your Lordship. Division simply means voting, Your Lordship, in the House.
Yes.
When the division happens, Your Lordship, it allows the Senate or the House to continue with proceedings until that division is complete. And Your Lordship, in that regard, the proceedings of that day are still continuing until that vote on the division is taken, Your Lordship. This is in the Senate standing orders, Your Lordship. Order 34-6, Your Lordship.
Order?
34-6 of the Senate standing orders, Your Lordship. We have at length explained that from paragraph 46 all the way downwards, Your Lordship. And I believe that
the petitioner's position.
Yes.
I've paused your time. The petitioner's position is that the Gazette notice shows that this was a predetermined process where the outcome was notified to the general public before the vote actually took place. Is that factually correct?
No, Your Lordship, that is not factually correct because of the explanation I have just given.
Part of the reason we open court, you can see that I am logged in.
Yes.
It's for the benefit of persons who are following this proceeding.
Yes.
So in as much as I've read your various responses,
Okay.
please articulate that so that they are able to understand.
Okay. So, Your Lordship, I have given Your Lordship the standing orders, the relevant standing order, which is 34-6.
Yes.
Now, Your Lordship, upon the close of submissions by the parties,
Yes.
the following events transpired, Your Lordship.
Upon the close of submissions
By the parties.
before the Senate.
Before the Senate, yes, Your Lordship. The following events transpired. I make reference to paragraph 47 of our response to the petition and the collection.
Yes.
Your Lordship, 1, the Senate Majority Leader moved a motion
Yes.
for the impeachment, Your Lordship.
Yes.
Secondly, Your Lordship, and just to summarize, also moved a motion pursuant to standing order number 111, sorry,
Yes.
that the debate for the proposed removal be limited, Your Lordship. These are from the standing orders, Your Lordship.
Yes.
And Your Lordship, once that was complete, a division was proposed, Your Lordship. All this happened in the day gazetted for the impeachment, Your Lordship. Now, Your Lordship, once the division was proposed, then under the standing orders, Your Lordship, division has to be complete before the business of the day is concluded, Your Lordship. And that is exactly what happened.
Okay, the time is back.
Yes. So, Your Lordship, it is only after the division and the taking of the vote that the process was concluded, Your Lordship. And in any case, that is why the Gazette notice reads that date, because it is the date when the business was complete, Your Lordship. It does not spill over to the next day, Your Lordship.
Yes.
And so, Your Lordship, I think with that, and barring a clarification from the court, I would beg to rest my submissions on that, Your Lordship.
You have quite a bit of time, 6 minutes, 42 seconds. You're comfortable?
Yes, I'm comfortable, but I can donate to an interest.
Submissions.
Thank you, Your Lordship.
Mr. Lorry?
Thank you very much, my Lord. On the part of the first interested party,
Yes.
we have filed written submissions dated 2nd October 2024 alongside our list of authorities,
Yes.
also filed and dated on given date, my Lord. We wish to rely wholly on the contents of these submissions and the authorities placed before you, my Lord. My Lord, we will further wish to associate ourselves with the submissions of the petitioner who has just highlighted them before I rose on my feet. Your Lordship, these submissions are in support of the petitioner's application dated 21st August 2024 and in opposition to the application by the respondent dated 3rd September 2024.
Yes.
Lord, in light of saving judicial time, I may not wish to regurgitate what has been said by my learned senior, Mr. Mwangaza, and also my learned colleague, Mr. Mutuma.
Yes.
Your Lordship, the application by the petitioner was filed after the petitioner, Her Excellency Governor Kawira Mwangaza, underwent an impeachment process, was marred with unconstitutionality, in bad faith, and tainted with procedural impropriety,
Yes.
as will be demonstrated at the full hearing of the instant petition, my Lord.
Yes.
My Lord, the application for the conservatory orders, my Lord, was summarized in the case of Wilson Kaberian Kunja versus the Magistrates and Judges Vetting Board and another, that is constitutional petition number 154 of 2016 at the High Court in Nairobi. It is authority number 1 in our list of authorities.
Yes.
The principles have been well enlisted in this particular case, and I would just like to summarize that the applicant must demonstrate that they have a prima facie case with a likelihood of success unless the court grants the conservatory orders. There is a real danger that the applicant will suffer prejudice as a result of the violation or threatened violation, and further, if the conservatory orders are not granted, then the petition will be rendered nugatory. From the summary that I have just been able to lay down, the first interested party has laid down the issues for this court to warrant this court's determination in our written submissions. And my Lord, the issues are 5 of them, and I will list them. Whether the applicant has established a prima facie case to warrant the issuance of the orders.
Mr. Lawyer,
Yes.
I think the counsel for the petitioners sent us those things.
Yes.
While they are different authorities, they
Yes.
will speak. The principles were long established.
Yes.
So maybe you can skip that to the end.
Yes, my lord, that forms the substratum of my submissions because these principles have been laid out and I was actually intending to avoid regurgitating the points that have been already laid out. But perhaps, my lord, just to go into the issues without repeating the authorities because they are on record for the judge, for the court to be able to decipher. My lord, as I delve into the first issue, and as was said by my learned colleague, Mr. Mutuma, on the issue of the prima facie case, my lord,
Yes.
it has been stated by the principal.
The challenge that the court has
Yes,
is those, you can go all the way back to the 1950s.
yes,
You can even go beyond it on what is prima facie case.
yes.
I'd be constrained to record something twice.
My lord, is the position of the court then that I just adopt my submissions because these issues and these principles are well laid out? Unless the court is inclined to make me just adopt my submissions, we will be guided by yourself.
I'd want to save the environment by conserving ink, so writing twice may not
Yes.
be the best way.
Yes.
What I wish you to highlight
Yes.
is more of the why.
Yes.
That the role of an interested party has been well defined
Yes.
all the way up to the Supreme Court. Why is the interested party saying that these conservatory orders should be confirmed and extended to judgment?
Yes.
That you could use your time on that, please.
Perhaps, my lord, just to give you, although this is not in my written submissions,
Yes.
we were constrained to only file written submissions. I didn't file a response. But perhaps just to come to bring to the court up to speed of the functions of the first interested party,
Yes.
they are laid out under section 20.
Yes.
And part of the functions of the first interested party is to consider matters of common interest to the county governments.
Yes.
That is part of the mandate that has been bestowed upon the first interested party.
Yes.
And impeachment of county governors has been a matter of concern to the first interested party, specifically, my lord, with regards to the issue of the procedure and the process that was followed.
Yes.
My lord, the law that relates to removal of governors from office is laid down under Article 181
Yes.
and also under Section 33 of the County Governments Act, my lord.
Yes.
But my lord, I will wish to submit that part of the processes that have been adopted both by the assemblies and the senates have been through jurisprudence of these courts. So the first interested party takes a lot of interest with the impeachment process to be able to follow through, albeit in a very neutral process, my lord, but just to be able to see through
Yes.
that the procedures that have been laid out, the procedures with regards to fair hearing,
Yes.
fair administrative action, the rights of elected, specifically governors, to hold office under the provisions of Article 38 have been laid out, my lord. That is the specific interest that the first interested party has with regards to this particular process, my lord. Without, my lord, that was just a background. Without, my lord, going into the meat of whether a prima facie case has been laid out, my lord, allow me to skip into that so that I can just canvass the rest without necessarily regurgitating what my learned colleague,
Yes.
Mr. Mutuma, has said. What is the likelihood of the prejudice? That is my second point on my written submissions, which concerns itself with whether there is a likelihood of prejudice if the conservatory orders are not issued, my lord. The prejudice that the petitioner is likely to suffer, my lord, pursuant to this impeachment process,
Yes.
in the failure of the conservatory orders, my lord, there are processes that kick into place. The first process is that, in line with the assumption to office of the Governor's Act, the deputy governor is then sworn in, my lord.
Yes.
What are the consequences of the deputy governor getting sworn into office, my lord? And the prejudice that the petitioner will suffer in the unlikely event of the court not granting these conservatory orders, my lord, automatically there will be a change in the whole executive of the county government, save from in the position of governor. The rest of the members automatically go with the outgoing governor, if so.
Yes.
This leads to a complete shift in the governance of the county, my lord. There is a likelihood of possible changes in policies. As my lord, you're aware, the governor, being the head of the county, is the #1 policy holder, my lord. So there is a likely change in policy. There is a likely change in some of the legislation that then operationalize the policies that have been put into place by the administration.
Yes.
My lord, there is a constituent that is not presently before you that may not have the audience. Those are the CCs, members of the County Executive Committee. The prejudice that they may suffer, my lord, once they go out by operation of law, what then happens to some of their obligations, my lord? Some of them may have running facilities. I don't speak for them, but that is the prejudice that they may be able to suffer, my lord, if these changes are likely to be occasioned, my lord.
Yes.
As I finalize on that point, there is no prejudice whatsoever, we submit, in issuance of the conservatory orders, pending the hearing and determination, and we will pray we have an expedited one of the petition that has been filed before you, my lord.
Yes.
The next point, my lord, is whether the substratum of the petition will be rendered negative without the conservatory orders being put into place, my lord.
Mr. Kawira, please mute. Yes.
My lord, as I've stated earlier on, the substratum of this petition may be reduced into an academic exercise if the subject matter, that is the removal, is not preserved pending the hearing and determination of the petition. And as my lord has been stated, there are already tribal issues that have been highlighted by my learned colleague, Mr. Mutuma. Tribal issues with regards to compliance with court orders, my lord.
Yes.
With regards to the fair hearing that was afforded to the governor in the Senate. With regards to a predated gazette notice, according to the petitioner.
Yes.
My lord, we submit that if these conservatory orders are not put in place, which are very critical in preserving the subject matter, pending to the court's determination of the petition, then the governor will suffer undue prejudice, my lord.
Yes.
I do not wish to restate what I've already said with regards to the organizational structures being changed in the county. I wish to save the court's time. The other issue is whether the granting of these orders is in public interest.
Yes.
My Lord, we submit that it is in public interest that these conservatory orders are maintained for continuity of service in the county government of Meru, my Lord. My Lord, we have seen, yes.
There's a deputy governor in place.
Yes.
How would services be disrupted? Delivery of public services be disrupted by that deputy governor becoming the governor?
My Lord, it is not about the person of the deputy governor. As I said, once the governor ceases being governor and a deputy governor assumes office, there is supposed to be legally a change. The county executive committee members who are appointed directly by the governor cease to hold office. These county executive committee members are the ones who are in charge of the departments and dockets, and they supervise the rest of the people below them. So this change,
Is there anything to bar their reappointment?
there is absolutely nothing, but they cease holding office, my Lord.
Yes, continue.
Thank you, my Lord. My Lord, it is in public interest, as I finalize on this point, because the people of Meru exercise their sovereign power by electing the petitioner into office, my Lord. My Lord, we submit that it is in public interest to maintain the status quo pending the hearing and determination of this instant petition, so as to ensure that the electorate who put their vote to the governor receive services from her administration pending the hearing and determination of the issues that have been raised or conversed or will be conversed in the petition. As I said, my Lord, this is against the background. Yes, my Lord.
Mr. Makere made a point that perhaps the status quo, when we use that phrase status quo, the status quo was that there was an impeachment.
Yes.
By resolution of the Senate. And you have also used the word status quo, the term status quo.
Thank you.
But yourselves and your counterpart appear to have different interpretations.
Yes. Yes.
When I issued those orders, what was the status?
My Lord, the status pending the issuance of the orders was that the Senate had voted to uphold. The status upon the issuance of the orders, which is the prevailing status up to now, in my own view, my Lord, is that there is an order that has stayed that particular upholding by the Senate. That is how I interpret it.
Before my orders?
Yes.
What was the status?
As I said, the status quo before your orders was that the Senate had voted to impeach, to uphold the impeachment, my Lord. Yes.
And how was that status, that circumstance, against the public interest?
The public interest is that, as I have said, my Lord, the people of Meru exercise their sovereign right to go and elect, and which they did, my Lord. And as such, they have a right to receive services from the administration of the person that we elected, my Lord.
Okay, move on.
My Lord, we have seen in the recent past continuous impeachment attempts by the County Assembly of Meru against the petitioner.
Yes.
And it is in public interest that, my Lord, and this is the very first one, my Lord, where the Senate voted to uphold, my Lord. It is in public interest that the conservatory orders in place remain until such a time that the process that led to the Senate upholding this impeachment process is determined by this court, my Lord.
So the public interest is that the petitioners laid out in the petition should be canvassed substantively.
Yes, as they continue receiving service from the person whom they elected into office, my lord.
Canvassed substantively as the people to services from person they elected to office. We have about 2 minutes, 15 seconds.
My lord, I'm just making my winding remarks. My lord, the last issue in my submissions is whether the omission of the Senate from the proceedings render the petition incurably defective. I do not wish to regurgitate, as I said. I rely wholly on what was submitted by my learned senior, Mr. Ngoya, as well as what is in the text of my submissions, because it's a copy and paste, my lord.
Yes.
And as I finalize, I would like to state that even though the impeachment process is a quasi-judicial process, my lord, it is governed by the rule of law, which we are all called upon to uphold.
Yes.
I do not wish to state any further. I wish to rest my submissions there. Thank you very much, my lord.
Thank you. Council, you have 20 minutes.
Good afternoon, my lord.
Good afternoon. And you're the only one who's had the courtesy to wish me a good afternoon. Yes.
My name is Herman, once again. I'll be submitting on behalf of the second interested party, that is Federation of Kenyan Women Lawyers, FIDA.
Yes.
To give a brief background, FIDA has an application to join the proceedings as an interested party on 5th of September 2016.
Please speak a little bit louder.
We could invite my learned friend and give us opportunity.
Please sit near a microphone. Yes, Ms. Maya?
Yes. The second interested party made an application to be joined as an interested party to these proceedings on 5th September 2024. In the hearing conducted on 24th and 25th of September 2024, by consent, it was agreed that the interested party to be allowed to be part of the proceedings. These submissions that I'm here to present, dated on 2nd October 2024,
Yes.
are made in support of the petitioner's application dated 21st August 2024 and in opposition of the respondent's application dated 3rd September 2024.
Yes.
Secondly, I associate with the submissions by the petitioner and the first interested party, and therefore will be very brief so as not to repeat what has already been said. For that reason, I will go straight to the issues that the second interested party put forward for determination in the matter. So the first issue is whether the petitioner has met the threshold for issuance of conservatory orders. Secondly is whether the ex parte conservatory orders issued on 21st August 2024 ought to be reviewed, varied, set aside and or discharged. And third, who bears the cost of this application? To the first issue is whether the petitioner has met the threshold for issuance of conservatory orders. I do not wish to repeat the principles that have been stated by the petitioner's counsel. However, I wish to highlight that conservatory orders are granted on the inherent merit of a case, bearing in mind public interest, the constitutional values, and the proportionate magnitude and priority levels attributed to the relevant case. Further, conservatory orders are issued in exercise of the discretion of a court.
Yes.
The second interested party relied on the case of Gatirao Peter Munya versus Dixon Mwenda Kithinji and two others. That's at 20, the citation is 2014 EKLR for the courts that have made on the conservatory order being public in nature. And therefore, what is more important in this case is that the constitutional edict to be protected and that it be observed by members of the Senate and of the County Assembly elected as representatives of Kenyans, the citizens of Kenya. Therefore, misuse of such powers that the members of the County Assembly and the Senate have should not be allowed by the court. It is on this premise that we implore the court to uphold the conservatory orders and that the same to not be set aside. And to my second issue on the exercise of discretion by the court. My Lord, the court is alive to the social constructs in Kenya, the patriarchy in our societies, and the general dynamics of our society.
Just a moment, Counsel. Did FIDA file an affidavit?
No.
So I think we can just skip the observations about the general nature of our society. Unless they are founded on an affidavit, those we cannot read and rely.
I am guided. Having said that, that is the end of my subject.
You had outlined a third issue, of course. You had outlined a third issue.
I adopt the submissions and pray that the court rely on those in determining the matter of costs.
Thank you, Counsel.
Thank you, Your Lordship. Allow me on behalf of the third interested party to urge you, Your Lordship, while the conservatory orders were not deserved and ought to be discharged. My Lord, we rely on our written submissions dated the 30th of September 2024.
Dated
30th September 2024, and the case laws embedded on those submissions, Your Lordship.
Yes.
My Lord, I will submit to you on three limbs. The first is on public interest. My Lord, the second is on the question of nugatory. And my Lord, lastly, on the balance of convenience. My Lord, my departure point is Article 1 of our Constitution.
Yes.
And which, my Lord, provides that all the sovereign power belongs to the people. And my Lord, under Sub-Article 2, the people are allowed to exercise that sovereign power either directly or through the elected representatives.
Yes.
My Lord, the people of Meru County through the elected representatives, being the members of the county assembly,
Yes.
elected to impeach their governor.
Yes.
My Lord, the propriety of the procedure which they followed was clear, and I believe it has been well explained by the respondent in this petition. My Lord, public interest, I would want you to be guided on what the Supreme Court has said in petition number 10 and 11 consolidated of 2024. That is the case of Dock Workers Union and Okio Mutata versus KPA and others.
Yes.
And Your Lordship, the Supreme Court was very, very candid that the third ground that a court should consider while granting or denying conservatory orders is the impact of such orders beyond the parties to the case, and should the order be granted or denied, what is the or maintain the conservatory order, as this petition is going to be rendered nugatory. My Lord, we humbly submit that the position of a governor, with all due respect, Your Lordship, is not personal to any individual. It is a constitutional office. The holders of that office are public officers within the meaning of the law.
Yes.
My Lord, no person can cling or individualize the position of a governor. As such, Your Lordship, the law provides for mechanisms of removal of a governor, and that is exactly what has happened in the matter before you, my Lord. My Lord, it is trite, and the court was kind enough to